Bam, let go of my arm, you're hurting me. Today I'm going to talk about domestic battery. When the facts are true, that's very bad. But when the facts are false, that's even worse. This is attorney Patrick Silva. Stick around and find out. Today I'm going to break down Penal Code 243E1 in California. I'm going to go through some examples where the person was guilty, some examples where the person was falsely accused. I'll break down the code, make it very simple to understand. Let's get into it. Into its simplest form. What is it and who does it protect? Let's put it in layman terms. An unlawful touching against a person that's in a protected class. Who is in that protected class? It could be a spouse, ex-spouse, girlfriend, ex-girlfriend, fiance, ex-fiance, somebody you lived with, someone you used to live with. What do you have to do to get arrested under California Penal Code 243E1? That person's in the protected class and you did something, and we'll call it an unlawful touching. Now let's get some examples of where it's true and where it's not. Let's get into some of the key details before we get through the examples. There has to be a willful use of force or violence. Willful, that means intentional, and it has to be against that person who's in the protected class. It's somebody that you most likely live with or had a live-in relationship with, or you had a child with. That's the most common example. Now let's talk about 243 as an arrest and 243 as being charged. The police come out, their training is to de-escalate, separate the people. If there's no visible signs, and you don't need visible signs of injuries or bruise or scratch or anything to be arrested or to be charged with 243E1 in California. But the police job is to promote safety. How do you promote safety? They separate the people. If someone says that he touched me, that person says, I didn't touch her. Well, guess what? They're going to make a call. Somebody's going to jail, separate them. Now let's go into some examples. Here's a common fact pattern that we see in court a lot. There's an argument. Let's say husband and wife. Husband and wife are arguing over something. It's usually about money or kids. They're arguing, they've been drinking. She throws a glass of wine at him, or a glass or empty. He blocks it. He's trying to leave, and she's blocking his doorway. He grabs her, moves her out of the way. Is that a force? Yes. Can the cops arrest him on it? Yes. Will the district attorney file on it? I don't know. That's a big maybe. Do you have a defense? Yes. Because she's blocking your way, you used a reasonable amount of force in order to move them so you could de-escalate and leave. That's most likely a fact pattern for 12 people in a jury box to hear and decide. Now, what are some of the penalties? And this is where it gets crazy. If you plead guilty or no contest to a 243E1 in California, you're going to lose your gun rights. You're going to do 52 weeks every week of a batter's treatment program. And if you miss, that's called a violation of probation. And if you screw that up enough, they're going to send you to county jail for a year. There'll be a $2,000 fine and possibly a year in jail. If you plead guilty to that, you're not going to jail unless there's bad injuries. You might be doing some trash duty, tree farm, community service, or house arrest. Let's go through a common example of what I see when it's a false allegation. You have to look at motive and why a person would make a false allegation. Let's give an example of a husband and wife. They have 1 or 2 children, 5 to 7. They're in family law court. The wife's listening to her girlfriends at the workplace, and they say, well, if you file a domestic violence, one is you get them kicked out of the house on a restraining order, and 2, you're most likely going to be the primary custodial parent, even if the husband was the stay-at-home husband and she went to work. So that's the ramifications of a false allegation. You got to imagine if you're a family law court judge and you're having to decipher and decide who's telling the truth and who's not. I actually talked to one of the judges once, and I was asking him, how do you cut through the bullshit and decide who's a liar, who's not? And this is what he said, and it made sense. This guy had been on the bench for 30 years, and he's basically a living, walking, talking truth detector. He said whoever gave the best detailed set of facts was the one that he believed. And that was just his perspective. I said, well, it kind of makes sense. So I sat in those courts back then. I'd see, okay, who's telling the truth? Who has the best story? I started using his paradigm, and yeah, it kind of seemed, but who knows? You never know who's telling the truth and who's not. Now let's go through an example I see in court all the time as well. There's a husband and wife, they're arguing, he's grabbing his keys to leave. She gets in front of the door and she says, "You're not leaving until we talk this out." And he's like, "Well, wait a minute, it's not gonna be good. Something happened." He wants to leave, she's blocking the doorway. He grabs her with more force than is necessary, throws her to the side, and leaves. She calls the cops. "He threw me, I fell, I hit my knee, it hurts, I got a scratch." Cops show up. He says, "Yep, I did it." She says, "Yep, that's what he did." Well, guess what? On that type of fact pattern, he's getting arrested and he's going to get charged. Here's the question though, does he have a legal defense on trying to defensive necessity? He had to leave because she was blocking the doorway. Maybe she could be charged with false imprisonment because she was in California, false imprisonment, blocking the doorway. I've seen DAs charge this. But was his use of force reasonable? I think it will be a sliding scale on what is reasonable. If it goes to jury, was that throwing force enough, or could he have just moved her because he's 6 foot 260, she's 5'4", 140? Could he have just moved her? So that's a fact pattern we see a lot. That could go either way. Let's talk about this fact pattern on where the cops show up. We don't know who the hell did what. In this type of case, we'll call him Johnny. We'll call her Johnny and Jeanette. They come from the casinos. They're arguing. They're drunk. A sliding glass door breaks. We don't know who the hell broke it. She's cut. The neighbors call the cops because they live in, we'll call it a area of homes that are built up on each other. There's 6 feet between the two homes, almost like a condo. Cops come up. Johnny's talking smack. She doesn't say anything. Finally, the cop gets her to say, "Well, yeah, did he cut you?" "Yeah, the door. He slammed the door. He kicked the door. The glass flew on me and now I'm cut. Yes, I want him arrested." This type of case where Johnny worked, he would have lost his job. He'd been there over 15 years. He hired me and we were saying, okay, we're going to have to take this to trial and see if we could get 12 people in a jury box to listen to our side of the story. And you win or lose a case on a domestic violence based on your investigation. And he didn't know a whole lot about this girl. They'd been living together shortly. We started digging into her past, found out that she had a history of lying, a history of stealing, and she had made false allegations of this exact nature against an old boyfriend and against her brother. Now, my investigator went out and got 11 statements. All these people said, yeah, Jeanette's flipping crazy when she's off her meds. Well, she was off her meds during that time period. Well, we set up for trial, and she had to hire her own lawyer because if she got on the stand and told the truth, she was going to be charged by the district attorney with making a false statement to a police officer, and that's a crime, false report. They, being the district attorney, will throw that type of scare into a, quote, a victim in order to get them to stick with the same story. Well, we weren't backing down. We went to trial, and as we're waiting for a courtroom, my client's like, shit, if you could get something, let's take it. So I'm negotiating with the DA, and I ultimately got misdemeanor playing loud music. So he pled to that, no fine, no probation, nothing. Just they got the quote, the guilty plea on playing loud music. We got the domestic violence wiped out. He kept his job, and they got back together. They started going to counseling. They worked through their things, and today they're still married, happily married, beautiful child, and it worked out for them. So maybe the government doesn't have to get involved in every type of scenario in a person's life. There's an old saying that you don't have to walk up to the gallows and put the noose around your neck so the hangman can pull the ripcord and kill you. That just means exercise your Fifth Amendment, shut the heck up. You don't have to make a statement. If there's ever a call out to a person's house, this is what the district attorney is going to look at. What the heck was said to 911? What does the victim say to the police? And what does the accused say to the police? If they show up and you make a statement saying, yeah, I touched her. Yes, it was willfully. Yes, it was forceful. You're going to jail. And guess what? You're going to get charged. So that's what they look at. The short answer is, 1, don't lose your temper. Don't get in an argument. And don't have the police come to your door. And 2, if they do, shut the heck up. This is Attorney Patrick Silva. Hope you like this video.